thank you all for joining us. It is 2 o'clock Eastern Standard Time here in the US. Thank you all for joining us for this webinar. My name is Dustin Saldarriaga. I'm an associate at Scott Legal PC. If you're here today, you may already have an E-2 visa, or at least considering one, and you'd be in very good company. Our firm was actually founded on an E-2 visa, 8 going on 9 years ago by our speaker today, Ian Scott. Our firm has a focus on investor visas and has processed hundreds of them. We've also helped some of our clients move from an E-2 visa to a green card. And that is the topic of our webinar today. We'll be talking about the various green card options that are available to individuals who are on an E-2 visa. Before we get started, I wanted to touch on a few things. This webinar is part of a series. We try to do at least 2 webinars a month, and those are on a variety of immigration topics. We already have a number of webinars scheduled, and we'll continually be adding more. We also do upload our webinars to our YouTube channel. So if you'd like to check out our past webinars, please do search for Scott Legal PC on YouTube. At the end of this webinar, we'll be sending out a few things to all of you. We will be sharing the PowerPoint presentation that you see on your screen. We'll also share a link where you can sign up for the upcoming webinars. We will also be sending you a link where you can watch the recording for this webinar. The webinar is being recorded, and as I mentioned, most of our webinars we do put on YouTube. The email will also send a link to our YouTube channel as well. A few housekeeping items. We do plan to save a few minutes at the end for questions, but I encourage everyone to go ahead and send questions as they come up. You can send them to me through either the Q&A function on Zoom or the chat box. I'll be checking both and send them in. If there's a good moment for me to share them with Ian, I'll do so. Otherwise, I'll save them for the end of the presentation, but please don't hesitate if anything comes to your mind. Again, my name is Dustin. I will be the moderator for this webinar. We're very fortunate, as I mentioned, to have Ian Scott here today to speak with us. Ian is the founder of Scott Legal. He has a vast amount of experience processing E-2 visas and has personally navigated the process himself on a variety of visas. He also has extensive experience with the green card options that we'll be speaking about today. So to kick everything off, a question for you, Ian. Does an E-2 visa lead to a green card?
Great, thank you very much, Dustin, and welcome to everyone here. So it's a great question, and it's one that we receive often. And the answer to the question is a clear no. But the interesting thing with respect to the answer to the question is that there aren't any non-immigrant visas that lead to a green card. In fact, the system in the United States is very different from the system in a lot of other countries. And in a lot of other countries, the country will look at how long you've been in the country, whether you speak the language, how educated you are, your age, a lot of different factors. And those particular factors, they're kind of getting at a point system, and they're looking to see whether or not the person can accumulate a certain number of points. And sometimes having a visa in that particular country will add to that particular point system as well. And then once they do that, then they can get some type of permanent residency. But in the US, it's very different. In the US, you could be on a non-immigrant visa for 10, 15, 20 years, and it doesn't lead to a green card. Instead, the way that the system works is that there are a list of green cards, and you see on this screen the list of family-based green cards and list of employment-based green cards. And if you're eligible for the green card category, you can apply. So, for example, if you are on an E-2 visa, or even if you're not on an E-2 visa and you want to apply for a national interest waiver, you look at the national interest waiver EB2 criteria, and if you're eligible, you can apply. Similarly, if you're under a family-based category, if you have a U.S. citizen brother or sister in the country and you don't mind a very, very long wait, you can apply for a green card. So that in the U.S. that's the way that it works. It's just that there's a list of green card categories that all have specific requirements, and you can apply for those green cards if you're eligible. And for all of the categories, all of the green card categories, they do, one of the criteria is not a prior visa, a prior, a non-immigrant visa, et cetera, et cetera. There are sometimes categories that lend themselves well to applying. So for example, if someone was on an O1 visa based on extraordinary ability, and that's a non-immigrant temporary visa, then it might be that they also meet the criteria for an EB1 extraordinary ability visa. But the fact that they had an O1 is irrelevant for the purposes of applying for the EB1 visa. So just generally speaking, you see on the screen, the two main types of green cards. There are other types of green cards, but the two main types are family-based green cards. And when we're talking about immediate relatives are not the way that you and I would normally think of an immediate relative. Like, you think of a brother or sister as an immediate relative, but this is, really covering a couple of different categories. One, the spouse of a U.S. citizen, and the other category of a child who is 21 and a U.S. citizen that is sponsoring their parents. So those are the kind of immediate relative categories that we're talking about. And then the preference categories are the other categories. So for example, a U.S. citizen sibling can sponsor their brother or sister for a green card. It's going to take a long time, but they can do that. And that's kind of one of the things with these family-based categories is the immediate relative category. The green card is always available. Right, so it's always available. Whereas the other category is there's often going to be a long often going to be a long wait. And just on the employment-based side, and that's what we if you could just go back one, if you could test perfect. On the employment-based side, the employment-based visas are broken out in terms of EB1 through EB5, and each of these, with the exception of EB4, each of these we're going to spend a little bit of time talking about, because the EB1, EB2, EB3, and EB5 are all kind of common routes to obtain a green card when you have an E2 visa. So, perfect. So if we go to the perfect. Okay, so we talked about the immediate relative categories and the preference-based categories, but one of the things I wanted to touch on, and this really applies to all of the visas, all of the green cards, whether they're employment-based or family-based. But the way that the green card system works, another interesting aspect of it is that, with the exception of the immediate relative categories, there are only a certain number of green cards that can be issued in each category, and then that's further broken down by country. So, we saw EB1 through EB5, and then we saw the preference-based categories, and those preference-based categories, those are broken into subgroups of 5 different categories. And each of them will say, okay, we have 26,000 green cards that we can issue, and then and we can't issue more than 10% of that number to a particular country. So what ends up happening is once they meet those quotas, the other people who also have applied for a green card have to get in the line, right? So they're backlogged, and it's in some cases for years. So the example that I used before, if a U.S. citizen has a sibling that they want to sponsor for a green card, they can certainly start that process, but the green card will not be available for 14 or 15 years, right? So, and each of the categories have this kind of wait, depending on the category. Each of the categories have a wait, and if they do have a wait, then it's we'll call it backlogged for the purpose of this. But then when there is no wait, we say that the green card category is current. So that means that the person can apply for the green card right away. So that concept is going to come up in the employment-based green card categories as well. So that explanation, just do it once, but it can apply to both family-based and employment-based. The other thing that's going to apply, again, to both family-based and employment-based is, kind of how is it that we process green cards? So there are really 2 ways to process a green card. And one is if you're outside of the United States or in the United States. So that's, this particular way of processing a green card, you can be in the United States or you can be outside of the United States. And the way of processing is consular processing. So that means you're asking the consulate to process the green card for you. Now, the other way of doing it, you can only do this if you're in the United States, and that's doing an adjustment of status. So when you do a consular processing petition, you're going to be filing a DS-260. When you do an adjustment of status petition, you're going to be filing an I-485. And when you file the I-485 petition, that's always going to, if you're in the US and you're getting a green card, you're always going to file an I-485 petition. So it's whether it's an employment-based category, whether it's family-based category, you're always going to file an I-485 petition. And when you file that I-485 petition, it means that the green card category is current, but also when you do that, you're able to file employment and travel authorization. So you can file for work authorization and you can file for travel authorization. So now let's jump into the employment-based categories and talk about them a little bit. So the first employment-based green card category is EB1A, and that's extraordinary ability. Now, we're not going to spend a lot of time on this category because while we have processed green cards for people who had E-2 visas under the EB1A extraordinary ability category, it's not that common. Right. So but it is, but it is an option. So we wanted to present it to you. So in order to be eligible under this criteria, you see the list of 8 or 10, 1, 2, 3, 4, 5, 6, let's say 10 criteria that are listed here. And in order to be eligible for this green card, you have to meet at least 3 of the criteria here. So let's take, one that's easy to explain. The evidence that you command a high salary or other significant high remuneration in relation to others in the field. So let's say somebody was, applying as an entrepreneur, for example, right? So they were saying that my extraordinary ability is I'm an entrepreneur and I've had many startups that have been successful, et cetera. We would look to see how much money that person has made in the past. So let's say that they, were an entrepreneur and they started a company and then they were making, $3 million a year. And then you look to the government publishes statistics on what the average business person would make, and let's say they say that that's $300,000, and then we'd say, well, the person made $3 million or $2 million, and the average is 300,000, so that person probably has met that particular criteria, right? So you go through and see if the person meets at least 3 of the criteria. And that's kind of the starting point. Now, what we've done here is we've highlighted, you see in bold, we've highlighted kind of the 4 criteria that would be most often used when someone is moving from an E2 to EB1A. So you can take a look at those, but this is a fairly complicated process, and the evidence that you'd have to submit is significant. Like, for example, if you're providing evidence of original scientific or scholarly artistic business related contributions, a lot of the time you'd want to submit evidence related to intellectual property, that maybe you've patented something, like mechanism of doing business or something like that. You might want to submit evidence that shows that you're asked to speak at conferences, that you want expert opinion letters from individuals indicating your business acumen, et cetera, and specific things that you've done. So it is a fairly complex, it is a fairly complex petition, but one that's available. Now, the other thing to keep in mind when you're looking at an EB1A extraordinary ability petition is that when you look at an O1, so the non-immigrant equivalent of this petition, so the non-immigrant means that it's not a green card, is an O1. Right now, when you look at an O1 has very similar criteria and says that if you meet 3 that are on the list, then you can get an O1. But with an O1, if you meet 3 that are on the list, it ends there. You're going to get the visa. With EB1A, unfortunately, even after you've met 3 of the criteria that are listed here, then the government will do a second analysis, which is extremely subjective, where they sit back and they say, okay, well, we're going to look at all of the evidence and we're going to make a subjective determination as to whether or not the person rises to the level of extraordinary ability. So, this particular determination, as I said, it's extremely subjective, and often petitions can be denied at that stage with just the explanation that they don't believe that the person rises to the level of extraordinary ability. So very, very difficult to challenge. So, but as I said, it is a green card category that's available, and we have done it for people who have been on E2 visas. So definitely something to consider. The other interesting thing about this particular petition is it's a petition that allows you to self-petition. So it means you don't need a company, you don't need an employer, you don't need a company. So you're allowed to fill out the petition and self-petition. So that's something to keep in mind. I think that when you're looking at the extraordinary ability, sometimes people kind of want to move to it because they're on an E2 visa, they start to raise capital, and then they no longer have the ownership interest of 50% that allows them to keep the E2 visa. So that's one of the things we see with entrepreneurs, and sometimes you can use what's going on in your own company to support some of these criteria. Because the fact that others are investing in your company, you might be able to point to some things that show that you have kind of an original business related contribution and things like that. So definitely something to consider. We talked about the two-step process. The first, they pick the three. If you meet three, then you move to the second step. And then, as we talked about before, this particular process is going to be whether you're in the U.S. or outside the U.S., you're going to file an I-140. So for any employment-based green card petition. Any employment-based green card petition with the exception of EB5, you're going to file an I-140. And then you are going to file an I-485 or do consular processing. Now, let's just kind of talk about this a little bit more because it illustrates some of the concepts I talked about earlier. So the EB1A category is one reason it's a great category is because right now it's current. And for every single country, it's current right now. So what that means is that if someone, and you'll see this where it can be an issue for some other countries. So let's say that someone was born in India, right? And they had an E2 visa because they have a passport from the UK. So E2 visa, as we know, it's based on your passport. Green cards are not based on your passport in terms of which country you're charged to for the purpose of whether the green card is available. So if you're born in India and you have an E2 visa because you have a UK passport, you would really be looking to EB1A because EB2, what we're going to talk about, national interest waiver next, EB2 wouldn't benefit you because you may have a 9 or 10-year wait for the visa because India is delayed. So when you're always kind of looking at, when you're looking at the different categories and you're developing a particular strategy, you always have to look at what is it that can work for me. Because you're going to have to take into account timing, which country you were born in, because as I said, green card is based on the country of birth, and see what would work. And if you are in the United States, as I said, if you file the I-485, because this particular category is current, you can file the I-485. You can file the I-765, which is the work authorization, and also the travel authorization documents as well. So something to keep in mind. And the other kind of last bit of information on extraordinary ability EB1 petitions is they are available for premium processing. So you can pay the government $2,500 and premium process this particular petition and have an answer at least as to whether or not the government is going to approve your petition within a couple of weeks. So. Perfect. So now let's move to, probably one of my favorites with respect to moving from an E2 visa to a green card, and that is EB2 national interest waiver. Now, one thing to keep in mind is that we have a completely separate webinar just on EB2 national interest waiver. So what I go over here definitely can be supplemented with, either attending that webinar in the future, or if you go to our YouTube channel, we have old versions of this complete webinar. Usually the webinar is like an hour, right? So we go into a fair amount of depth with respect to it. But this is a great category, and a lot of our E2 clients have selected this particular category. And as I said, if you're born in India or if you're born in China, it's not going to work for you because you will have a long wait, often too long, too long of a wait, so it's not going to work for you. But for most other countries, this EB2 category is current, so it works really well. So a couple of things with this. So before 2016, it was really the end of 2016, so we'll say 2017. We didn't look at this category for moving from E2 to green card because this particular category was never used, because the standard was based on a particular case, and the case really, at the end of the day, the case looked like it was, this particular category was useful for, for someone who invented the COVID vaccine might apply for under this particular category, but really, really strict and difficult criteria to meet and never considered for entrepreneurs, right? So, but then at the end of 2016, so as I said, really 2017, and even later, because what ended up happening is that there were a number of different cases that went, because what happens is sometimes people apply for a visa benefit, they're denied, and then they sue the government, and then those cases or appeal, and then those cases are decided by courts. And then those courts or appeals offices will issue decisions, and those decisions guide future adjudication of the particular area. So really, it wasn't even probably until 2018 that this particular category started to be used in earnest for entrepreneurs, and it was governed by this particular case that was decided at the end of 2016 called Danisar, and the particular case specifically mentioned entrepreneurs as well, so that made it good. So in terms of to be eligible under this category, the applicant would have to meet 3 criteria. So the first criteria is that whatever the person is proposing, whatever the endeavor is, has to be of national importance, right? So now one of the good things about entrepreneurs is the national importance could be jobs or the economic impact. So you could apply under this category and say that, the national interest is, or the national importance or the national interest is job creation, if your job creation was significant, right? So if you were certainly more than 10 jobs, that's, it's certain, not just a guidance from EB5, but probably a lot more than 10 jobs. But if job creation was going to be significant. But what we tend to like to do is to mix the kind of job creation, if we're using that as one of the aspects of national importance, with something else that the applicant is doing. So we have this one individual that we're doing, she we did an E2 for her. We're now doing a national interest waiver. She in her company, she does a couple of things. Her company's focused on providing kind of support in a very computer friendly way to marginalized groups. So that's kind of, we say that's in the national interest. And then the consulting company also does a number of different things in terms of government contracts. So we say that's in the national interest. But as much as we can point to, and you really have to think out of the box with these particular types of petitions, because they're not cookie cutter. They're not kind of, they're not just like, oh, well, here's the criteria and let's stick some things in here. You have to, part of what we do is we give people a document, which is kind of an introduction document that asks a number of different questions. And then we set up a meeting with them and start talking about, talking about it and talking about what it is we're going to focus on and how we're going to narrow down, or broadly, it doesn't have to be narrow, what is the national interest and what is the national importance that they're addressing. And often that kind of introduction document is like a little questionnaire that we do often. I think it really pulls out useful information that we could focus on, because these are kind of one of the funnest fun for immigration nerds, like that kind of stuff, so like me. So they're fun petitions for us, because they're all unique, and they're all kind of really focusing on developing strategies around how it is we're going to meet the criteria. So definitely this one, the fact that people are on an E2, I think that the one aspect, like economic impact, is often one that we can use, and then depending on what other aspects of their business that they are doing, we can utilize that too. And sometimes it's easier than sometimes it's quite easy. We have this one E2 client that is doing a bunch of gene technology research. That's what his company does, right? So we say job creation, but then we also say this other national interest, which makes it easy. We have some E2 visa people who are cybersecurity experts. So, we do job creation, but then we also do the fact that cybersecurity is of national importance to the government, things like that. So depending on what area you're in, this is definitely a category that can be utilized. And you do have to think outside of the box, because it is going to apply to a vast, it applies to much more than it did before, and often we can make it work. The second criteria is that the entrepreneur is well positioned to advance the proposed endeavor. Now, when you read this on its face, it looks like easy, like it looks straightforward and easy, but it's one of the key reasons that these petitions get denied. So a few things that we have to do here. So one, we have to show that the person, has the background and experience. So we do point to the resume, point to their job experience, etc. To the extent that the individual wants to, like some of the same things that come up in E2, where they'll approve a national interest waiver and an E2 based on a plan, but they want to make sure that you're going to be able to execute it, that it's not so speculative that that you can't that you're not going to be able to actually get through it. So sometimes we'll show that the person has contracts in place that that are ready to go, that they maybe have other investments that people are making, that and that they are they are well positioned to kind of move forward with whatever it is number one is, right? Whatever that proposed endeavor is, that they're well positioned to do that. So and we're going to go through an example that talks about this. And if we don't have it in this slide deck, I'll talk about it. I may be thinking of the actual national interest waiver. The actual national interest waiver presentation that we do, and I probably am, so I'll talk about it after I finish the slide up. And then the final prong is that the government should waive the labor certification process. Now, this is a simple one for entrepreneurs, because we argue first and foremost that the labor certification process doesn't apply to people who own over 50% of their company. So that's but then also what we tend to do is we tend to point to a lot of the same aspects that we pointed to in the for EB1. So maybe we don't point to them in the sense that we're trying to meet the EB1 criteria, but we kind of say, well, you should waive the labor certification process because the person has this, the person is so accomplished. They have this particular education, or they have these awards that they have won, and they have these expert opinion letters of people who think they're fantastic and would really contribute to American society and things like that. So that tends to be an easier one to meet. I'd say that the probably the most difficult one actually is prong 2, and then prong 1, depending on where you are with respect to what it is that you say that you're going to be doing, that can be difficult too. And we have some really great articles as well on our website that get at the the entrepreneur is well positioned to advance the proposed endeavor. Some really great articles that talk about some of the things that the government will consider. So let me just go through one example as well for Dustin, just move the slide. I just want to see if we do have that. Okay, no, we don't. Okay, that's fine. So I just go back to the NAW. Yeah, perfect. So I wanted this particular example. We talk about it more in the national interest waiver webinar, but one of the cases that came up that so this was an individual who applied for a national interest waiver after Danisar and was denied. Then he appealed, and then the appeals court wrote a decision and said, no, he should get the national interest waiver, and this is why. So this was an individual who was a vet, and he came back to the United States, and he started an organization that was going to assist other vets. And it was, modest in terms of it wasn't an organization that was going to make a ton of money, et cetera. It was done to assist other vets, to integrate them back into society, the workforce, et cetera. He had a number of different government contracts that showed that he was well positioned to do it because the governments were happy with him happy for him to assist with this. He had kind of the experience. He was a vet himself. His educational background lent itself well. He produced a lot of documentation that showed the benefits to the American society of integrating people who've served their country that come back, and different things like that. So he was approved, and it was under the entrepreneur category. He was starting a business, right? That's so it's and he also used job creation. So I think that the case really kind of sets the roadmap for some of the things that we consider when we do EB2 cases under the national interest waiver criteria, and it's we have a number of cases that we're working on now where people are moving from E2 to national interest waiver, and I think it's the premier category, and we're going to talk about why EB5 is not, but I think it's the premier category for moving from E2 to a green card. So then the final thing under this category is that there are threshold considerations, and these are under EB2 regardless of whether you're doing national interest waiver or PERM, which is what we're going to talk about next. Is you have to have an advanced degree, so that's either going to be a master's degree or a bachelor's degree plus 5 years experience, or you're going to have what's called exceptional ability. So that's not to be confused with extraordinary ability, which extraordinary ability we talked about under EB1, but there's a different definition for exceptional ability, and they list about 7 criteria that you have to meet. And again, for more details on this, go to the EB2 webinar. We have a number of them, I'm sure in January, but as I said, if you don't want to wait till January, you can go to our YouTube channel and look at the webinars. I believe there are at least 3 of them on our YouTube channel. So
great. And Ian, the only thing I wanted to add to your enthusiasm for the EB2 and IW is for those who were born in mainland China, the date is actually 2019. So we're not too far off. Now for India, it is 2012. So Chinese nationals may have a bit of hope as well.
No, that's great. And I didn't realize it moved forward. So that's great.
Yeah, it jumped quite a bit.
Excellent. So then the next category in terms of getting a green card for people on an E2 is one we've done a lot of as well. So this is EB2 PERM and EB3 PERM. So EB2, we talked about, the EB2 criteria. EB2 criteria is broken out into national interest waiver and then PERM. And then EB3, which covers, green cards for unskilled workers, professionals, and others as well. So now what these are it's basically a company sponsoring you for a green card. So keep in mind a couple of things. When you're on an E2, you can't sponsor yourself. You can't sponsor your family for a green card, right? So they're not, that's not going to work. That's not a way to get a green card. But what we've done a lot of is E2 applicant has their company, he or she is running the company, and then their spouse gets a job somewhere else because they're allowed, they have work authorization. He or she can work anywhere they want. And then the other company sponsors them for a green card, and then the other spouse joins in that green card process. So that's very common, and that happens often. I'm not going to spend a lot of time going through the EB2 and EB3 PERM process. We do have another webinar where we talk about that in more detail. And again, if you go to our YouTube channel, you can see an old one. I don't know if we have one of those set up in the next month or 2, but you can definitely see this, this talked about in more detail on our YouTube channel. But it is a very common way for people to get a green card, and it's a traditional way that people in the States get green cards where their companies just sponsor them for a green card. And it takes a little bit of time, but it's probably the most common way that people get green cards. Okay, so now we come to a monster of a topic, which is EB5. Now EB5 is, we could have a 2-hour webinar on EB5 because it's so complicated, and so much so that most immigration lawyers don't do them. So we do because we work on a lot of investor visas and things like that. But most immigration firms don't do them. But we have a number. In fact, we just had an EB5 direct approval 2 days ago. What today's Tuesday, so no, one day ago, yesterday, we had an EB5 Direct Investment approval. And what that means is the person, we did an E2 for the person, they had a company and they also invested $500,000 in the company. And we applied for them, it was 2 years ago. And they just got their approval yesterday so now they, now they'll go through the steps for the green card. We'll go through exactly what those are. So it is, and we have a number, we probably have like, at least 10 other applications that are pending for direct investment green cards. It's just they take a long time to be approved. So it is a very, very common way to do it. So let's back up before we go to the bullet points. So someone's on an E2, right? And then they're applying for an E2 or they're on an E2 and they're saying, how do I get a green card? Well, one way is EB5. So if you're on an E2 and you've invested money in the US, then sometimes some of that money that you invested can count towards your EB5 investment. So let's talk about the rules as they are today. Today, the rules say that for a direct investment EB5, you have to invest $500,000 or $1 million, but most likely $500,000, because the rules with respect to when you can invest $500,000 are pretty lax because they're based on the old rules. So the old rules said that if you're in an area which is called a TEA, a targeted employment area, then you would invest 500,000. But keep in mind the example that I just went over with you. The person's company was in Soho in Manhattan, so that and it qualified because the new rules were very lax. They allowed you to link together census tracts and and so when they changed the rules, they did away with all that. But right now, because of a lawsuit, everything is reverted back to the old rules. So if you applied for an EB5 right now, you could invest 500,000. And keep in mind what you hear in the news. The fact that the program is shut down for EB5 doesn't apply to direct investment. It's only shut down for regional centers. So you could apply for a regional center, a direct investment EB5 now, and invest $500,000 and submit your application and apply for the green card. That is very possible right now because everything's under the old rules. Now, what the green card, to get a green card, what it says is that you invest money in a new commercial enterprise. But new commercial enterprise means any enterprise that was started, I think it's after 1990 or something, like a long time ago, right? So even if one of the direct investment EB5s that we're doing, it's for this farm, and they invested the money I want to say 20 years ago, and but they're applying now for the EB5, but they invested the money a long time ago. A few things you have to make sure that that the investment counts, because not everything can be included. E2 allows you to include, for example, legal fees. EB5 doesn't. So there's certain things that when you're looking at how am I getting to the 500,000? What have I spent the money on? Similarly, if you purchased, let's say you purchased a gas station for $200,000, E2 would allow you to do that, but EB5 doesn't. For EB5, you can't take money and pay a seller and then say you want an EB5. In order to get EB5, you have to actually invest the money in a business, and that money that you've invested has to create jobs. So some E2 investments, like let's say someone bought a restaurant, or someone bought a gas station, or bought a convenience store, or bought whatever, a production company, whatever, those couldn't qualify for EB5 until the person had reinvested the 500,000, right? So that's something to keep in mind. Also, investments can be made over time, so you can kind of add up your investments. The other thing to keep in mind is that, let's say someone invested, $50,000, got an E2, and then their company made $2 million over the last couple of years, and they took that $2 million and spent it on different things. That's not investment for EB5. Investment for EB5 is money that has, your personal funds that have been invested and spent. So in that particular example, the only investment that you would have made so far for the purposes of EB5 is the $50,000. So something to keep in mind. And just that there are other E2 to EB5 differences. Like I did a training session for a bunch of immigration lawyers, two of them, and we spent an hour talking about the differences between E2 and EB5, and because there are differences, they're not the same visa. Some of the things that you've done for E2 you can use for EB5, but not everything. You know, for example, source of funds, even though on paper the two requirements look the same, they're not at all. Like, so source of funds for EB5 is very exacting. So, you know, usually sometimes thousands of pages of documents, depending on what the source of funds are, but just very, very exacting. And, you know, and there has to be some form of equity. EB5 doesn't require that you own, you know, 50% of the company. You can own 1%, and you don't, and they do, you know, EB5 is a lot more permissive with respect to structuring things that in essence would be somewhat passive, right? So that's another benefit of EB5. With EB5, you do have to create 10 full-time jobs. You have a lot of time to do it, but it is full-time jobs. It's not part-time jobs. It's not, and they have to be US citizens or green card holders. So with E2, there's no set number. You can have part-time, full-time contractors, things like that. But EB5 is very, very specific. If you are doing direct investment, you need a detailed business plan. I'd say similar to E2, but I think it would be a little bit more expansive than E2. And any investment that you make has to be linked to job creation. Like, it's this is all about job creation. So if you, you know, let's say that you invested in a company that already had 10 workers, when you invested the $500,000, you would have to then create another 10 jobs so that there would be 20 workers, because the 10 were already there. So your money didn't contribute to that particular job creation. The EB5, the first petition that's filed is an I-526 petition, and unfortunately the I-485 cannot be filed concurrently. So all the other petitions, as long as they're current, we talked about the EB2, EB1, as long as the visa is current, the green card is current, you can file the I-485 concurrently. But unfortunately for EB5, which I'm not sure why they did this, especially given how long they're taking to approve the petitions, but unfortunately you have to wait till the I-526 has been approved to file the I-485, and they are taking years. So the person I just mentioned that was just approved yesterday, hers took 2 years, but the only reason it took 2 years is because the regional center program has been paused since June. So probably all the people who were working on regional center EB5s are now being moved to work on direct investment EB5s, and, you know, as a result of that. But you know, with that, like, you know, Dustin, who's moderating today, I think he sued the US government 4 or 5 times now, because they've taken over 2 years to adjudicate, you know, EB5 petition. So we sue them and say that you're taking too long. And then usually what happens is they come back and say, okay, well, you know, rather than fight it, they just say, oh, we'll actually do our job. We'll actually, you know, do it. Usually they do that. So yeah, but definitely something to keep in mind. As I said, you know, a number of our E2 clients do it. It is a substantial investment, but you're investing in your own company, right? So it's not like you're giving the money to somebody else. So something definitely to consider. We're going to skip by this one.
Skip the example.
Yeah,
perfect.
Yeah, perfect. Yeah. Great. Okay. So, you know, some other things to definitely kind of consider, because you don't want to forget about these things. Like, I was, you know, it was an acquaintance that I had that I was working on. You know, I knew him and his family from Canada. You know, he's a Turkish national. His wife is Canadian. And you know, I called him. We were doing an E2 for him, and I because I, you know, knew him from Canada. I called him up and I said, "Oh, by the way, you know, you should apply for the diversity lottery." I think it was the next day or something like that. And he's like, "Oh, I have to take a picture, and my wife's in Greece, and it's going to be too much trouble." I said, "Well, it's up to you." I said, "But, you know, I would probably, it's, you know, it's worth applying," because they were, you know, they really wanted a green card because their 2 daughters play tennis, and he was already in the United States, and it was, you know, they needed residents there, right? That's why they were doing the E2. So he ended up getting everything together, and he applied and he won. And he, you know, him and his family all have green cards now and are in the States. So, you know, diversity lottery, if you're eligible, because not all countries are eligible. He was eligible because he's Turkish national. So he was not, because his wife, for example, wouldn't have been eligible because she was Canadian. You know, they look at how many people have immigrated to the US over the last 5 years, and if the numbers are over a certain amount, then that particular country is not eligible. So countries like Canada, UK, things like that, they're not usually not eligible. So, but definitely apply. It's a short application. It's every October or whatever. And I know a number of people who have won, like personally, like, it's a number of people who have won. So it's humanitarian-based green cards. Always keep an eye out for those. You help someone with police with a crime, that might be available, and others as well, whether it's asylum and or different things like that. Just we do these come up, like where someone either, let's say, they can't renew their E2 or something comes up, and they and there's, oh well, like I can't go back to this place because I'm going to be persecuted. So then maybe there's an asylum claim or something like that. Hopefully immigration reform will come. Like there's always a talk of this being a really popular visa, creating U.S. jobs. And there are bills in Congress that talk about, giving a green card if you have a certain number of jobs. So hopefully those things will get traction and we might see something there. So I think that with all of these options, I think that, you always have to pay particular attention to the timing, because if you have an E2 and you, so for example, the individual I was talking about, that she did an E2 and we did an EB5 for her, we actually also were doing an NIW for her because we thought that the EB5 was going to take forever, and she probably was eligible for an NIW as well. Now, the interesting thing about this is she still may do the NIW, right? Because the NIW is a strong case. We're almost done it. And, she now has an approved I-526, but she, the way that the EB5 works is that you get the green card, and then 2 years later, you have to file yet another application that takes years to be approved to remove the conditions to show that you've created the jobs. So the NIW might be a little easier for her to apply, because one of the reasons we were going to move forward the NIW as well is because when we did the NIW, we could file the I-485 at the same time. Now she has options. So I actually have a meeting with her tomorrow to talk about what the options are with respect to what to do with respect to this. Whenever you apply for a green card, you want to make sure that you have time on your visa. You don't want to be in a position where you're in the middle of a green card process and you have to renew your E2 visa. You may not get it approved, right? E2 visa is not a dual intent visa. It's about as close as it can get. You don't have to maintain property in your home country or anything like that, but something to consider. We talked about parallel green card strategies. Often people, like I said in that example I just gave you, where the applicant was applying for multiple green cards at the same time, and there's nothing wrong with that. There's, whichever one's approved first, you can take it, or the one that gives you the most amount of benefit, you can take it. And really, the thing is planning is planning is key with respect to all of this.
Great. So Ian, we actually only had a couple remaining questions, both of them about dual intent. I think this one's directly related to what you were just talking about. While you're on an E2 visa, if someone files an EB5 application, is there a conflict of interest?
Yeah, so it's not a conflict of interest. You can definitely file one, but you can definitely file one. But what you want to say is that on the application, and we one of the key takeaways with respect to any I-526 petition that's filed, there's a question on the form that says, do you plan on adjusting status or doing consular processing? So if an immigration attorney checked the box of, I plan on doing adjustment of status, big mistake. Always check the box that you're doing consular processing. You can always change it later. But what it gives you the ability to do is, even if you do have to renew your E2 visa, or if you left the country and you're re-entering, then you can say to the government that, well, yeah, I plan to process at a consulate, because there's dual intent. There's no prohibition against someone entering the US if they want a green card. That's not the prohibition. The prohibition is someone entering the US and adjusting, knowing that they're going to adjust status in the US. So we've been successful even at when an I-526 petition has been pending, and we've had applicants that needed to renew their B1, B2 visa, and we've been successful getting them that renewed, and them getting the B1, B2, and then coming to the US. And then, because they're basically saying that, yeah, I'm going through the green card process. However, I don't plan on adjusting status when I go to the US. That's not my intention. So that's how that would work.
Perfect. And another dual intent related question. This participant says their father and their sister have applied for green cards. Does that affect this individual's E2 application?
No, no, it shouldn't. No, it shouldn't. It
Perfect.
shouldn't. No, it shouldn't. It's too far removed. I mean, anything could affect, but I think no, I think that wouldn't affect it.
Great. And then if someone's been turned down or denied, their E2 application has been denied, does that impact their future application for either an E2 or a green card?
Well, I think that a couple things. If you're on ESTA, like if you have ESTA, or if you're eligible for ESTA and you have a visa that's denied, then you're no longer eligible for ESTA, right? So we had an applicant who he applied on his own for an E2, he was denied, and I think he went straight from the consulate to the airport to try and fly to the US because he didn't realize we didn't do his application for him. He did it on his own, and his ESTA was already canceled by the time he got to the airport. It wasn't even one day. So then he hired us and he got the visa and came to the US. So that's the impact. Now, in terms of if you're denied an E2 visa, in terms of getting another E2 visa, it's really just going to depend on whether or not you are eligible. With respect to the green card, though, the green card is different. The green card, it is if you meet the eligibility criteria for a green card and you're not inadmissible. When I say inadmissible, means that you don't have a criminal, you don't have medical issues. There are a bunch of things that make someone inadmissible, like they, committed fraud, or they, have severe criminal activity, or they, this is a whole list. You tuberculosis. There are a bunch of things that make someone inadmissible. But the green card is a lot more. The applications themselves might be somewhat objective, somewhat subjective. Like an EB1 might be subjective in terms of getting it, but they're not looking at things like a previous visa was denied or something like that. Whereas E visas are looking at that because it's part of the whole assessment of ties to home country and the non-immigrant nature of it. But when you're looking at green cards, you're really looking just at have you met the criteria, and are you admissible?
Great. And a few more questions rolling in. Is it possible to change status from TN to E2 from within the US?
Yes.
Yes, it is. And processing time for an E2 visa. What are we seeing in terms of processing time?
Yeah, so I think that if you're in the US, that's predictable. You could do premium processing. So 2 weeks, but I'd say that it really depends on the consulate. So I mean, it ranges anywhere from 2 weeks to consulates that are just saying, we have people that have been waiting for 1.5 years and they still don't have their appointments, right? So I think it's a very, very wide range. However, I will say that things are getting better. Everything is COVID related, right? So things are getting better. In some major high volume consulates, you're definitely starting to see more activity. We had people even with long waits that just the other day someone sent me something. Oh, we got an appointment in London, and they had they had been writing all the time, like, because there's nothing we can do. Like, even if you have other immigration lawyers, like, give them a break. There's nothing they can do, right? The consulates they don't care, right? They don't care that we contact them. They don't care, so we can follow up, but the consulates, it's unfortunately, they have a process. They have a process for, a lot of them have a process for expedited appointments. A lot of them have a process for how it is you submit E2 visa applications, etc. But unfortunately, we had someone in Madrid that waited 1.5 years, and it was a renewal with a simple renewal, like where he had like 3 full-time employees, millions of dollars in revenue or whatever. We kept on, getting back to them, and I think the only answer we got from them is, "Where's your file?" And we had to we mailed it to them, and then we had to mail it to them again. registered mail, of course, right? Not just mail into. So yeah, but the timing is really uncertain. I'd say that the best way to look at it, if you're just starting the process, I'd say that you can always have some indication now, right? Like in terms of if you hire a lawyer and the lawyer can check what either they have cases that are pending, or we can check with our colleagues in different chapters to see what their experience is at that particular consulate. So.
Perfect. Related to the EB5, could you clarify in what circumstances is $500,000 required, and in what circumstances $1 million?
Sure. So $500,000 is required if the company premises where the people will be working is in what's called the targeted employment area. And targeted employment area is defined as an area where the unemployment rate is 1.5 times the national average, or what's defined as a rural area as defined by the government. Now, that's a simple explanation. However, based on the old rules, there was a lot of flexibility with respect to how it is you came up with that 1.5 times the national average, because as I said, that one that was just approved, she applied under the old rules, and her office is in Soho in Manhattan. So that would be saying that Soho has an unemployment rate of 1.5 times the national average, which is obviously not the case, right? But the old rules allowed you to link census tracts together. So her census tract went right through up the Bronx. And so she was able to, we were able to, because we actually had to do it. We were able to come up to the 1.5 times the national average, because under the old rules, we could just kind of add a bunch of, like, we went up through the Bronx, Washington Heights, and as long as they were joined, we could keep on adding them until we got to the 1.5, and we were able to do it. And those are the rules that apply now. The rules that apply now. The old rules apply, so you could still do that now. Yeah.
Perfect. I think we have time for just a few more questions. Can someone apply for an E-2 in a consulate outside of one's home country?
You can, if the consulate will permit you to apply there. So you'd have to check, like, so for example, we do a lot of applications in Toronto for people who are in the United States. Some consulates don't have any requirements, not many, but some consulates don't have any requirements with respect to who applies there. But generally speaking, most consulates require that you have some residency ties before you apply there.
Perfect. And then a question about dependents, E-2 dependents. Is there work authorization that comes with that, or the ability to study in the US if you're a child or a spouse dependent?
Yeah, so everyone gets to study. So spouse and children get to study. Only spouse gets to work.
Perfect. And then finally, I think the last question we had was regarding the general process and pricing. Ian, I don't know if you want to speak to that.
Sure. So each one of these visas has different prices. So I'd say that if you had a particular visa that you were interested in, then write to us and we can definitely send you more information on pricing.
Perfect. Well, Ian, thank you so much for taking the time to share your wisdom and experience with everyone. And to the participants, we had a great group participating today. So thank you all for taking the time. Again, we will follow up by email with a link to the future webinars, as well as our YouTube channel. So please do stay in touch. Please visit us on future webinars. And if we can be of any help along the way, please do visit our website. It's a quite straightforward process to set up a consultation if you'd like to discuss your specific circumstances. Ian, thank you again. Everyone have a wonderful day.